I don't know if someone's got it on. Let me show you. Oh, there she is. Ma'am, what's your name? Can you hear me, ma'am?
Oh, me?
Yes. What is your name?
My name's Christine McLean. I just allowed my audio, so that's why I didn't hear anything until then.
What is your name again?
Christine McLean.
What matter are you here for?
The office of Michael please, for American Express.
Yep, Judge, she's on my case. It's a pretrial American Express.
Okay, we'll put you in the private meeting room.
Okay, thanks. Your Honor, I'm also here on another one, just so you know, credit acceptance for BJ Thomas.
Okay, sounds good. Thank you.
Oh, thank you, Your Honor.
On the record in the matter of Benjamin Levine versus Rebecca Smith, file number 22-02318 GC, counsel appearance.
Good morning, Your Honor. Corey Carpenter on behalf of the plaintiff. This is the date and time set for creditor's exam. I'm not sure trying to confirm
Your device is your device is going in and out.
Your Honor, to repeat myself, what I said is that I have not been able to confirm that the defendant was served. I would request a new date.
Yeah, we have a note in here that there was no service. Clerk's office, you said it? September 12th at 2 o'clock.
Can I confirm that 1 second, Your Honor? That will be fine. Thank you.
Okay, you're all set.
Have a nice day.
You too. On the record in the matter of Edgewood Villas versus Desiree Henry, file number 22-03865. Counsel appearance.
Morning, Your Honor. Brian Lum on behalf of the plaintiff.
Desiree Henry. Okay, today's the date and the time that's set for a motion to stop eviction. I have a motion to set aside or stop eviction filed by you, Ms. Henry. It says, I have denied anyone.
They have denied anyone.
Okay. That's not what you said. Okay, it says the have denied anyone to pay. I have had 3 agencies try to pay and have been turned down. Named your email as staff in office. Leon. I'm not following. Could you tell me what your motion is for?
So basically what happened was I went to the office because I needed a ledger for the people that was helping me pay the rent. And when I went up there, the lady in the office, Natasha, told me that Margaret, the manager lady, had emailed her to tell her that they can't accept my payment from me or from the agency. I said, well, why is that? Why can't they accept payment? She told me to pay her move. And she was like, I don't know. She's like, that's what I got in my email. I was like, all right, that's fine. I was like, I'm just gonna go back down to the court of motion because at this point, I was like, y'all playing with me. Then she told me, well, if you don't pay it, then you lose your Section 8. I was like, well, you're telling me that you see at the same thing you saying I can't pay, but then you're telling me I'm gonna lose my Section 8 if I don't pay. And then the agency, I got the email from them. I had sent it to your thing where basically when I left here on the 27th of July, I had them try to help them. They had decided they were gonna help me. They never wrote them back until August 4th.
Why isn't your client accepting her payment?
Your Honor, it's my understanding that it was a partial payment and going to the judgment.
It was never a partial payment.
You talked to me, not to him.
It was never a partial payment.
How much were you attempting to?
I only had to come up with $500. That's what the agency told me to do, and I did that. I came up with the money that they needed me to do, but when it was time for me, like I said, to go pay, they told me that they wasn't going to take.
You wanted to pay $500, and the agency's going to pay the balance.
They told me to pay $500. The agency.
What agency?
I had the Evan House payment and I had the City of Lansing.
Avon House and City of Lansing was gonna pay your balance?
They were gonna pay partial, but I mean, each one of them was paying something.
How much?
So like, I had to come up with 5, then the City of Lansing came up with 1,000, and then the other parts, the Evan House was coming up with the rest. Then I had a third agency that was coming up with something too, but they never, when they tried to write them, she told them that they wasn't gonna take the information. The third person, I forgot what the agency was called, but it was this CACS agency, and there was the City of Lansing, and it was the Evan House. The Evan House is the one who called me. They left the voicemail. The City of Lansing is the one who I sent the email about where he stated to me that he got the paperwork and he needed it, and I asked him for the letter.
Tell me exactly what agency and how much money each was gonna pay.
Well, I can't tell you what the other agency
Why
is
did
gonna pay.
You came to
Because-
court, you gotta tell me something or else you're getting out the property. I'm not gonna figure it out. You tell me how much an agency was gonna pay, you told me that it wasn't gonna be a partial payment. You were gonna pay 500, how much was City of Lansing gonna pay?
That's the only reason, the payment that I had to pay. The payment was the 500.
No, you're responsible for all of it, ma'am.
I got that
How
part.
much was the City of
But I'm
Lansing gonna pay?
saying, the City of Lansing was gonna pay $1,000. The other
How-
agency was gonna pay the rest of the
How
balance.
much, what is the rest?
It was the $2,769, so that I only had to pay that part of the payment of the 500.
Okay, and how much did Avon House say that they would pay?
The Evan House was gonna pay, I think they were gonna pay.
You don't have something from them telling you how much you were gonna pay?
They wasn't gonna be able, they couldn't give it to me. The only thing they could do was give me an estimate, because after they got the estimate after she gave me the estimate, she told me that she can't go on further because the Edgewood, when they called them over there to get the stuff, they wasn't giving it.
Where's the estimate?
I don't have that because it was over the phone. Me and her talked over the phone. I
Okay.
can talk to Miss, I can give you the name of the person, I can give you
Who's
the
the
phone number.
person? And then the other agency was what agency?
City of Lansing.
City, I thought you said it was 3 agencies.
No, the City of Lansing, the Evan House, and then I can't remember the name of it. I think it was CACS or Save This and Fall. They had called me because they had got my number from the other agency. And when they called me, I was like, well, I got a problem because the property ain't trying to take the payment.
So you went to go pay the $500
When I went into the office, I went in there to get a ledger from her.
from whom?
That was before I even knew about the $500
Okay, you went to go get a ledger and what happened?
from the office, from Ms. Natasha that was working in the office.
Okay,
So I had been trying to go get the ledger from her for 3 days. They never was in the office. So finally I got a hold of the maintenance man. I was like, well, hey, is the office open? He's like, they never in that office. I was like, all right, cool. Well, if you see him up there, let me know. So he was like, go up there about 11. I went up there at 11. When I got there, she told me that the payment that I couldn't pay, that they wasn't gonna accept my payment. I reported her in her office telling me that this lady told me her not to take my payment.
Natasha told you that someone else told you not to take their payment?
Natasha told me that Margaret, I don't know her name, the office manager, told them not to take my payment, even if it's from the agency or from myself.
Did she tell you why they said they weren't taking your payment?
Because I gotta move out by August 7th.
Okay, this is a eviction for non-payment of rent, so why wouldn't they take her agency payment?
To my knowledge, Your Honor, that's what I previously told you is that they would accept full payment.
Okay, well, typically,
partial payment.
the one agency doesn't pay all of the money. Okay, you have a client with you here today?
I do, Your Honor.
Okay, where's your client? Ma'am, can you come up? What's your name?
Martha?
Martha?
Yeah.
Okay, do you have any knowledge about Natasha telling Ms. Henry that payment was not be accepted?
Yes, the owners did not want to accept partial pay on,
Partial payment?
they didn't want to accept partial pay on the balances.
Okay, so she's supposed to get money from an agency to pay the other portion. She communicate that to your office?
We have nothing in writing or on paper. There's just a lot of
Back and forth?
talk.
Okay, yeah, I'm gonna adjourn this hearing. Go get us some writings from these agencies to tell us how much money they're gonna pay.
Okay.
All right?
They're definitely back in touch with them. I just can't get in touch. They won't pay anything if these people was not
I
giving
know,
up the
I'm gonna,
information.
don't cry. I'm going to adjourn the matter. So you can go to the City of Lansing to Avon House and whoever else called
I
you.
got the City of Lansing already. They didn't say what they was.
I want it
paying.
in writing.
I got the writing on here. He emailed me, he sent me the email that they sent him basically stating that they're not gonna take the payments.
Wait, the city of Lansing sent you an email with
Correct.
the amount they're gonna pay?
No,
No,
he sent me the email of basically everything. He told me to send everything I need to send in. I said, okay. I sent everything that I need to send in. He called my phone. He said,
who's he?
his name, I can't remember his name. I think it's John, the
Okay.
guy from the city of Lansing.
Okay.
That's who I've been working with. And he said, well, you gotta get in touch with them because they're not writing him back for them to get the ledger. I said, I'll go get the ledger myself. I went to.
And you have an email from the city of Lansing saying that?
I got I sent it to you in the, that little, what's the name box already.
You have an email?
Both
from-
of them.
From her?
I even emailed the video about me recording her stating that she wasn't gonna take my payment. And then she told me that you can lose your Section 8 if you don't pay your payment. I said, well, you're telling me not to pay it. You're saying that you're not gonna accept my
I
payment.
recognize all that, ma'am. I just want you to go to Evan House, have them put in writing what they're willing to pay. We need whatever the city of Lansing is supposed to be paying in writing. And then bring that back to court. If there was another agency, you need that in writing as well.
But I'm not gonna be able to get it in writing. The only thing I'll be able to get is that they're gonna be able to help me. Because.
No, we need to know how much they're gonna pay, because they may be only be able to help you with $5. We need to know what amount they said they're gonna pay.
Well, I can try to get him to see if he can send me that paper.
Tell them
Like,
the judge needs in writing
okay,
how much you're going to pay.
but see, that's the thing.
Repeat after me.
I keep telling him
Repeat
that.
after me.
I understand.
Repeat.
what you-
No, I didn't. Repeat after me.
Mhm.
The judge needs in writing
The judge is writing
how much
how much
you're going to pay.
you're gonna pay.
Say it again.
The judge needs in writing how much you're gonna pay, but they're not gonna.
Say it again.
I already,
Say it again.
the judge want me to know how much y'all gonna pay.
No, that's not what I told you to say. That's the problem. The judge needs in writing
Okay.
how much you're going to pay. Say it.
The judge needs in writing how much you're gonna pay.
Say it slower.
The judge needs to know how much you're gonna pay.
No, that's not what I said.
I
You
got
said-
it when I get
no,
there.
no,
I promise you.
No, I need,
But it's-
if you don't get it here, you're not gonna get it there, because there's a very crucial word that you're missing, is what I asked for.
You need it in writing.
Thank you.
But
I need in writing. I don't want to hear what they're not gonna do.
I tried to get it in writing before I came here,
We'll try again.
but they won't,
Or-
because
or-
these people won't sign the paper.
Look, so on side what paper that they're going to,
They need the lease agreement paper, the lease agreement. I sent it in. They said they gotta have one from the agency.
you need a lease from the agency?
No, any place that they say that you need help from, they have to get something from them stating that they're gonna accept the payment. If they don't give the paper.
I
to
know
them-
that when I asked you for you to bring to me that they're gonna accept the payment, I want to know how much they're willing to pay, and they can put
Okay.
that in writing.
All right.
And then you bring that to me. I think new rent is coming due now, if it hasn't already.
Mhm.
So now you gotta come up with some more money.
Mhm.
You prepared to do that?
Mhm.
Yes?
Yeah,
Okay. What are you gonna tell the agency?
that you need something in writing.
Thank you. Do we have an email from her?
Yeah, but when I print it, it doesn't print the whole thing, so I forward it.
Okay. Let me get a new date. 19th. September 19th at 2.
September 19th. All righty. Thank you.
You're welcome. Thank you. Okay, on the record in the matter of Hamilton Road versus Claude Miller, file number 23-01344. Council appearance.
Gene Turnwald, on behalf of Hamilton Road, a representative of Hamilton Road is here with me in my office.
Good morning, Your Honor. Darwin Fair on behalf of the defendants in this matter.
Okay, today's the date and the time that is set. We reset this matter. There was a motion to reinstate case that was granted back on July 26th. I was advised there was a case pending in the circuit court. What's going on with the circuit court matter?
The circuit court matter has been dismissed. It was utterly without merit. The parties in circuit court claim to be represented without an attorney. Yet I have no doubt an attorney drafted the documents. The matter is completely frivolous. Just to let the court know now, another game is being played. The circuit court matter, we've learned electronically, has been appealed. And now I have no doubt opposing counsel will begin claiming that somehow that frivolous appeal will somehow stay this matter. It doesn't. There's a court rule squarely on the matter. It's MCR 7.209 subsection A. To stay this matter now, because a judgment has been entered in the trial court, the circuit court, they need an order from that circuit court staying this matter. Otherwise, people will do exactly what he's going to try to do and delay the matter again because a frivolous appeal has been filed on a frivolous trial action. To get an appeal, they've got to post a bond. The bond would be approximately $130,000 to $140,000 on this property. They have no chance they're going to post the bond because they know their appeal is frivolous. They merely want to delay this matter, which they've done now for 4 months. I'm asking the court for immediate writ. The court inquired during the last hearing about an escrow account being opened. And there's a court rule on that. I know as the court's aware, the court rule is MCR 4.201 H2. It allows for an escrow to be opened anytime a trial is delayed more than 7 days. This matter now has been delayed almost 4 months. The original court filing was April 29th, 2023. The fair market value of this property in Pattongill in Colonial Village is, according to Zillow, is approximately $280,000. Zillow claims the estimate for rent is approximately $2,500 a month. Your Honor, I also happen to be a real estate broker in addition to being an attorney. I've been a real estate broker in the state of Michigan for approximately 10 years. I also help numerous clients manage numerous properties. We're very familiar with Colonial Village. I would estimate fair market value of a four bedroom, 4-bath, 2,200 square foot home, brick front, fenced yard, be at least $2,000 per month. In the motion, I was giving him a break. That's a mistake. I shouldn't be asking for $1,600 a month. $2,000 a month, I think, is very fair for that property. If any kind of more gains, appealing the writ or whatever happened, escrow should begin commencing May 1st when this thing was filed. 4 months now, $2,000 a month, $8,000 in escrow. And finally, most importantly, Your Honor, this is the 3rd time opposing counsel has appeared without any clients. He claims to represent occupants in an estate. The personal representative of the estate contacted my office and claimed she has nothing to do with this case. He's never named who the occupants are to shield them from civil liability for occupying the premises without paying rent. And again, the 3rd time now he's appeared without any clients. I'd ask the writ be issued immediately because he hasn't appeared without clients. Finally, Your Honor, now in the breakout room, I learned he's going to claim he hasn't received copy of this motion, yet somehow he's shown up here and known about the hearing. The proof of service.
Copy of what motion?
This current one we're arguing today.
Okay, the one that with the stay?
Yes, the proof of service states is mailed out, first class mail on August 11th. Today is August 24th, and he's physically here anyhow. All he's going to do is play games and delay more. I'm fed up with it, Your Honor. I'm sorry to get emotional. Thank you.
Thank you. Mr. Fair?
Well,
We're
Your Honor,
we're your clients, Mr. Fair.
they're not here, Judge, but I will say that the lawsuit is against the occupants. It's not against any individuals. It's the occupants. If they would have named individuals, that would have been a different story. But Judge, you know, the counsel wants to talk about how long he's been practicing law. I've been practicing law since 1980, and I specialize in real estate litigation. I've specialized in foreclosures, and I specialize in eviction hearings, and I've never been required to have my clients at a district court hearing when I'm representing them. This is
You're representing the occupants?
That's correct, Your Honor.
Okay, well, who are the occupants?
The occupants, Judge, are the plaintiffs in the circuit court case.
What are their names?
Their names are, and I'm pulling it up because I am not representing them, but I am pulling it up, Judge.
You say you're not representing them?
I'm not representing them in the circuit court.
No, I want to know who you're representing in this court.
Oh, and it's the same people who are in the circuit court, but I'm going to give the court the answer to that question. The individuals are.
Your Honor, just to interrupt briefly, just so you know, these circuit court people claim to have different addresses, each one of them, than the Patton-Gill address we're asking for possession of. They claim not to live there.
Well,
you don't know who you're representing? You don't know the names of your clients?
Yes, I do, Judge. If I could just have
What are
one
their
more.
names?
All right, I'm just pulling it up right here. It's Innovative Properties, 1997 LLC, Matthew Brown II, Betty Miller, and the estate of Claude L. Miller. Those individuals. Now,
Matthew Brown and Betty Miller and then the estate is who you're representing?
that's correct. And
Who
if I
is the
could
personal representative? Who is the personal representative?
the personal representative of the estate of Claude Miller is Betty Miller. That's the wife of the decedent Claude Miller. Now,
Okay, and then when I got some questions here. I got some questions. I'll let you know when you can feel free to go on your rant, but I'm getting clarification right now. Mr. Turnwald, you said that your office had conversation with Betty Miller?
Yes, she contacted my office. I supplied an affidavit. In the circuit court case, she claims her address is 530 Ivan Drive, apartment 111, Lansing, Michigan. She also claims not to have signed any of the circuit court documents, have no idea what it's about, no idea about the district court, said the property in question on Patton-Gill was foreclosed on, gone, over with. And we supplied an affidavit to the court on that matter.
Okay, how about this? How about Mr. Fair, we're gonna reset this and you bring your clients to court. I wanna see them.
Okay, and that's fine, Your Honor. I can do that. I guess my question, do I have to physically be there? Because if I do, I have to make arrangements to come from out of town, actually out of state, to be in
No,
your courtroom.
You can appear the same way you appeared today. I just need your clients because there seems to be some discrepancy about who you represent and whether or not you represent them. If they're representing and sending a affidavit stating that you're not representing them, then that's concerning. So let's have them come to court.
The affidavit was from my secretary, not from the client, not from Betty Miller.
Correct. Okay, but I got an affidavit. I got an affidavit from your secretary who said that Betty Miller told her that she didn't represent.
A person on the phone identified herself as Betty Miller and said,
right. So, right, and that was put into an affidavit signed by your staff. And so now we need to get.
My concern is delay.
We need.
That's what's going on.
We need Maybe there's a delay when I
Again.
speak. Maybe that's what's going on. I'm sorry?
Again, all this, my concern from day one here, here's what's going on, is delay.
I know
All
what your
wanna do-
concern, I don't want to hear your concerns again, all over again. I don't want to hear them anymore. I want the clients here, Mr. Fair. I'm gonna give you a new court date.
Absolutely, Judge. And Judge, you know, counsel, I have asked counsel if he would email me a copy of his pleadings because the mail is so slow. And I would ask.
We got a copy of it. Why is your mail so slow?
I have no idea, Judge. My office is downtown Detroit, and the mail in downtown Detroit has been notoriously slow. And that's why I asked counsel, just email me a copy. It's the easiest thing to do. And I would like a copy of what he filed today, but I have sent him an email, Judge, and that's why I want to put it on the record that it asked that he email me. I mean, that is how things are done now.
Okay, well, you just filed a proof of service indicating it was sent first class mail August 11th. I don't see, even with mail being slow, how it's reasonable that you would not have received it before today, which is the 24th. Maybe Mr. Turnwall would agree to email you or serve you via email in the future. Mr. Turnwall, is there a disagreement with serving him via email?
I just suspected once I sent him an email, he'd pretend he didn't get the email. You know, we could do both first class mail and email.
Easier to track an email than mail, first class.
Oh, he'll just say he missed it, didn't get it. Don't know.
No, Judge.
I'm not gonna go back and forth on hypotheticals. Please serve him via email then, if that's his request.
Okay.
Thanks, Your Honor. And Judge, I will.
September 19th at 2 p.m.
Your Honor, can I have a ruling on the escrow funds?
Well, Judge,
I have a note here from July 26th that you were supposed to file a motion with the court for the escrow.
We did, right here.
But no, we have an escrow order form that you need to submit to me for me to review and sign. I don't have that.
I don't have the form. I wasn't aware there was a form.
Yeah, that's typical. It's how I review escrow orders or requests and make orders.
And no knock on counsel, Judge, no knock on him, but you know, if you do this type of work, you know there's an escrow order that it's a form order. But having said that, Judge, if he sends me a copy, emails me a copy, I will respond to it before the 19th. Well before the 19th.
Yeah, I think it's a standard scale form. You can submit that and serve him a copy via email, and then the court will review it.
And that, I understand he's going to email to me also, so I can respond to that also.
I noted here that he's going to serve you electronically since your mail is slow, and then I'll give you an opportunity to respond. September 19th at 2 p.m. works for both calendars?
At 2 p.m.? Yes, Your Honor.
Yes, Your Honor.
Okay, we'll see you then.
Okay, thanks, Your Honor.
On the record in the matter of the people of the state of Michigan versus Cody Clower, file number 23-01846FY. Council appearance.
Jeff Ruddles on behalf of the people, Your Honor.
Hey, good morning, Your Honor. May it please the court. Nathan Towson on behalf of Mr. Clower, who's seated to my right. Today is the date and time for preliminary examination.
Mr. Clower can stand up.
Today is the date and time for preliminary examination in this matter. However, after conversations with the people, they have offered to dismiss count 1 in exchange for an added guilty plea to an added count 2 use of cocaine. The have advised my client to his rights. He's executed the advice of rights form, and that's been submitted to the court. We've also submitted the plea agreement form reflecting that deal. And additionally, the people have no objection to potential sentencing under 7411.
So I do have an offer submitted by you, Mr. Broderick, that reflects what was stated by the defense counsel. Typically, the prosecutor puts the offer on the record, not the defense.
That is the correct offer, though, yeah.
Thank you. Okay, and then you want to accept that offer?
Yes, Your Honor.
Okay, please raise your right hand. You solemnly swear or affirm the information you're going to provide is true to the best of your knowledge, information, or belief?
Yes, Your Honor.
Okay, if you have an advice of rights and the information sheet with today's date on it, there's a signature. That's your signature?
Yes, Your
It's pretty unique.
Honor. I'm not ready to sign.
Got it. Okay, so you read this document?
Yes, Your Honor.
You understand each of the rights listed here?
Yes, Your Honor.
You want to give up all of these rights in order to accept the offer?
Yes, Your
Okay, you understand that you have the right in this matter to proceed to a jury trial.
Yes, Your Honor.
You understand that at the time of jury trial, you have the right to the presumption of innocence. So you're innocent until proven guilty.
Yes, Your Honor.
You have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at trial.
Yes, Your Honor.
You have the right to see, hear, or question any other witnesses the prosecution intends to call.
Yes, Your Honor.
You have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you.
Yes, Your Honor.
You have the right to remain silent at trial and not have silence be used against you.
Yes, Your Honor.
And you're okay with giving up those rights today?
Yes, Your Honor.
Has anybody made any threats to you to get you to want to waive your rights and enter a guilty plea?
No, Your Honor.
Any promises being made to you in exchange for you entering a guilty plea today?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application.
Yes, Your Honor.
And also a guilty plea in this matter could result in a conviction that may have impact on travel or immigration status that you may be seeking.
Yes, Your Honor.
Okay. As to the added count 2 of use of a controlled substance, that being cocaine, how do you plead?
Guilty.
Okay, and are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Factual basis, counsel.
Thank you, Your Honor. Mr. Caller, on or about April 16th, 2023, the city of Lansing, county of Bingham, state of Michigan, did you use cocaine?
Yes.
Did you know it was cocaine?
Yes.
Were you prescribed or otherwise authorized to possess these?
Mr. Broderick, any questions?
Nothing from the people, Your Honor.
Satisfied with the factual basis, I'll accept your plea. I find your plea made freely, voluntarily, and intelligently. This matter is set for sentencing. The sentencing is going to be October 19th at 8:30 in the morning. When you leave here today, you need to go down one floor to the 5th floor to meet with our probation department so they can get you set up for a sentence interview and investigation. Did you undergo a substance abuse assessment recently? I do know that there was another matter, I think, in East Lansing, so I wasn't sure if you had a.
No, that was not.
Okay. Okay, so you're going to have to undergo a substance abuse assessment prior to your sentencing, okay?
Okay.
Okay. Okay, and then 7411, there was no objection to that. We'll see if you're eligible for that before the time of your sentencing.
Thank you, sir.
No problem, and you can appear via Zoom for sentencing long as you have appropriate video capability, okay?
Thank you.
Any additional matters for the record?
Just that bond, we continue, Judge.
Bond will continue. You're all set.
Thank you.
Thank you, Your Honor.
Okay, Mr. Werber, you and Ms. McLean McWayne, I'm sorry, are back. Are you all set with your pre-trial statement, or did?
We are all set and we have resolved it. We'd like to place our resolution on the record, Your Honor.
On the record, in the matter of American Express National versus Christine McWayne, file number 23-01066, council appearance.
Morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Okay, and Ms. McWayne is present today via Zoom without counsel, and the parties that privately come to a resolution.
Yes, we did, Your Honor.
Okay, what are the terms?
The party, thank you for the opportunity to meet in the breakout room. We had a very productive conversation. The defendant does not deny that she owes the money. She is just in a rough financial situation and she's trying to get back on her feet. The parties have agreed to enter into a consent judgment. Damages are $8,446.45 plus filing fee of $75 and a service fee of $50.30 for a total judgment in the amount of $8,571.75. There's not going to be any type of installment payment plan agreed on at this point, but the defendant plans to file a motion for installment payments, and at that point, plaintiff can decide if we want to object or not, and the court can order installment payment plan at that point.
Mr. McQueen, can you unmute your device? You have to unmute.
Ms. McQueen, if you tap on your phone on the very bottom, there should be a place. Yep, there you go.
I got it.
Okay, Ms. McQueen, is that true that you want to enter into judgment by consent?
Yes, that is true.
Okay, you raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Thank you. Now, you understand that you have the right in this matter to proceed to a trial?
Yes.
Okay, you want to give up your right to trial so that you can enter into judgment by consent?
Yes.
Okay, and you also understand that you could be represented by counsel in this matter. You would have to retain counsel, though. Would you want to waive your right to have counsel represent you?
What does that mean?
And a counsel is an attorney.
I will waive the rights for that.
Okay, sounds good. And so the amount of damages being sought is $8,446.45. You are agreeing by consent that you owe that amount, ma'am?
That's correct.
Plus the $75 for filing fee and a $50.30 service fee for a total of $8,571.75. That's the judgment you want to enter against you?
Yes.
Anybody threatening you to get you to enter judgment against you?
No.
Any promises being made to you to get you to
No.
enter judgment against you? Okay. And you do not, you're going to later file a motion for installment payments?
That's correct.
Okay. Okay, and then Mr. Werber, you're going to prepare the consent judgment paperwork for the court?
Yes, Your Honor, do you require me to mail it to the defendant for a signature, or you just want me to file it with the court?
I just want to know if you were going to file it, and then I'm going to ask Ms. McQueen, is she giving you permission to sign her name to that paperwork?
Perfect.
Yeah.
Ms. McQueen, okay, sounds good. So that means he'll complete the paperwork consistent with what we said here on the record. He'll sign your name with your permission, and then I'll review and sign that paperwork, and then judgment will enter by consent. Do you have any questions today, Ms. McQueen?
No.
Any additional matters for the record, counsel?
No.
Not on this matter, Your Honor.
Okay, you're all set, Ms. McQueen.
Thank you.
Thank you, Your Honor.
You're welcome. Thank you. Who is the gentleman with the red hat? Can you
That's my
unmute, sir?
other case, Your Honor. Credit acceptance versus BJ Thomas.
What's your name, sir?
BJ Thomas.
Okay. Did you need to speak with him, Mr. Werber?
We did go into a breakout room. The defendant did not want to discuss anything, so we're back in front of you, Your Honor.
You did not want to discuss anything. What does that mean, Mr. Thomas? You are here for a pretrial on a civil matter. You know that?
Yes.
Okay, so you need to complete a joint pretrial statement.
I don't understand what that actually is.
Okay, so that means that there's questions that need to be answered for the court from both parties so that we know how to set your next court dates.
Okay, I don't agree with what they're saying. And then
What do you mean you don't agree with what they're saying? You don't agree with that that you owe them any money, is what I'm assuming you're talking about?
Yeah, so it's so much more than that though, because.
Okay, well, today's not the day to talk about that. Today's the day to talk about the joint pretrial statement.
If I don't get it, if we're in dispute, how do we have a joint statement?
Easy. You go through the paper, you go through line by line. Mr. Werber knows how to complete that paperwork. He'll ask you questions about pleadings and discovery and motions, and then you all will answer that question. It doesn't sound like you are agreeing to any facts, so there won't be any admissions of facts from you, of course, because you dispute this. If there's an issue where you're filing a counterclaim, that will be noted. All that stuff needs to be completed.
Okay.
And Mr. Werber, you do have the joint pretrial statement form?
You know what, I'm looking, Your Honor, I was sent the notice to appear, a copy of defendant's answer, civil pretrial instructions. Is that what we need to? I don't have a joint pretrial form, no.
There should have been a sheet attached with the joint pretrial form.
It was just
joint pretrial statement.
Yeah, that was not attached to what I received. I received the Zoom instructions, the pretrial civil pretrial instructions, a copy of his answer, and a notice to appear.
Okay.
That's all I received.
Sounds good. My court staff is sending you a copy of the joint pretrial form that needs to be completed by both of you all. I'm going to put you back in a private meeting room.
Where are they going to send that to?
He's emailed it to you, I believe. We just got your email off the state bar. Is that accurate email for you?
gwerber@weberolseast.com?
Yes.
Okay, great. Perfect. Thank you very much. We'll do our best to fill it.
Sounds good. I'll be here. I'll put you in room 3.
Okay.
I don't get a copy.
You're already in room 3, Mr. Werber.
Oh, I don't have any invite to go to.
You're not going to get another invite. You got to go down to your screen where it says breakout room.
Got it. I got it. Sorry, Your Honor.
No problem. On the record, in the matter of the people of the state of Michigan versus Stephen Williams, file number 23-00434FY. Counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Stephanie Korndike on behalf of the defendant, Stephen Williams.
Okay, and Mr. Williams is present in the courtroom along with his counsel. Today is the date that's set for a preliminary examination. However, there's been an offer from the people. Mr. Brodowitz, what was the offer?
Yes, Your Honor. At this time, the people have offered for the defendant to plead to count 2 domestic violence with the second defense notice enhancement and a Killebrew agreement for no upfront jail, and then the people would dismiss count 1.
That's an accurate statement of the agreement, Your Honor.
Okay, and Mr. Williams, you want to accept that offer?
Yes, sir.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand down. I have an advice of rights with the plea information sheet with today's date on it. There's a signature here on the bottom. Is that your signature?
Yes, sir.
Did you read this document before you signed it?
Yes, sir.
You understand the rights listed here?
Yes, sir.
You want to waive each of these rights today?
Yes, sir.
Okay. You understand that you would be giving up your right to the presumption of innocence if you enter a guilty plea?
Yes, sir.
It means you're also going to give your right to trial, and you have the right to a jury trial. You understand that?
Yes, sir.
At the time of trial, you have the right to have the prosecution prove each element of the charge beyond a reasonable doubt. You want to give up that right as well.
Yes, sir.
You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses the prosecution intends to call against you. You have the right to call your own witnesses or present evidence at trial that you believe further a defense to the charge being brought against you. You want to do a feature of those rights as well?
Yes, sir.
Anybody make any threats to you to get you to waive your rights?
No, yeah.
Any promises being made to you to entice you to want to waive your rights?
No.
Okay, you're on probation still?
No.
Okay, when were you discharged from probation?
What was it?
When were you discharged from probation?
A few months ago.
Okay. At the time of your arraignment, which was June 28th, you were on probation though, correct?
No.
That's what it says here, currently on probation.
I may have been. I was incarcerated at the time.
You were incarcerated at the time,
Yes,
and you don't know when you were discharged from probation?
it would have been early August.
Okay. Because a guilty plea could have impact on probation status. Do you understand that?
Yes, sir.
Okay, and a guilty plea could also result in a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application. You understand that?
Yes, sir.
A guilty plea could also have impact on travel or immigration status, so you may be prohibited from visiting certain countries. You understand that?
Yes, sir.
And you want to give up your rights, understanding that?
Yes, sir.
There's a killabrew, that's a sentencing agreement between you and the prosecutor. I'm not a party to that. Okay, so I'm not agreeing that I won't put you in jail up front. You understand that?
Yes, sir.
Okay, if I decide at the time of your sentencing that I'm not going to agree with the killabrew, I'd let you know and give you the opportunity to withdraw your plea, okay?
Yes, sir.
Okay, are you entering a guilty plea to count 2 because you believe you're guilty?
Yes, sir.
Okay, as to the domestic violence, and count 2, second offense notice, so it makes it a misdemeanor, maximum penalty 1 year and or $1,000 in fines. How do you plead?
Good.
Factual basis?
Yes, Your Honor, thank you. Mr. Williams, on or about January 23 of 2023, were you in the city of Lansing in the county of Ingham?
Yes.
And where were you at that time?
The place I resided with the victim.
And Tara Hopkins, how do you know Miss Hopkins?
We were in a dating relationship.
You were in a dating relationship on January 23rd?
Yes.
And at that time and date, was there an argument between you and Miss Hopkins?
Yes.
And at that time, was there a physical touching of Miss Hopkins?
Yes.
And did she consent to that physical touching?
No.
Were you previously convicted of a domestic violence on or about September 25th of 2017?
Yes.
Are you unsure of the date you were convicted?
Yes.
But were you previously convicted of a domestic violence?
Against my stepfather, yes.
And so would this charge here then today make this a domestic violence second offense?
Yes.
I have no further questions.
Any questions, Mr. Bartlett?
Nothing from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing October 19th at 8:30 in the morning. When you leave here today, you need to go down 1 floor to the 5th floor. You need to meet with our probation department so they can get you set up for your pre-sentence interview, okay?
Can you repeat that again?
Yes, when you go, you're gonna go down to the 5th floor when you leave here to the probation department so that they can get you set up for your pre-sentence interview, okay? Your sentencing can be via Zoom if all parties consent, okay? You just need to have video and you need to be in a position where it's quiet and you can conduct a court proceeding appropriately, okay?
That is for the October 19th.
Correct.
Thank you.
You have any questions about that? Okay, on the record in the matter of the people of the state of Michigan versus Stephen Williams, and this is file number 23-02019. Counsel, your appearances on this record.
Jeff Bradowitz on behalf of the people, Your Honor.
Stephanie Korndike on behalf of the defendant, Stephen Williams.
Okay, so Mr. Williams, this matter was also scheduled for preliminary examination today, and my understanding is that the parties are waiving exams, is that correct?
Yes, Your Honor, at this time, after discussions with defense counsel, I believe the parties have agreed to conditionally waive their rights to preliminary examination here today. The people would move that this be bound over to the circuit court as charged in the complaint. I believe the waiver has already been signed by all parties.
That is a correct statement by the prosecutor, Your Honor.
Is there an offer at all?
Not in district court, Your Honor. Negotiations would be set to continue up in circuit court.
Okay. And so, Mr. Williams, in this file, you recognize that you have the right to have a preliminary examination.
Yes, sir.
You understand the purpose of the preliminary examination?
Yes.
And that is to require the prosecution to meet their burden of probable cause. So they need to establish that they have probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. You understand that?
Yes, sir.
You want to unconditionally waive your examination?
Yes, sir.
So that means you can't change your mind after this matter is bound over. Once you waive it, it's gone, and you're not waiving this because someone made any promises to induce you to do that, correct? Okay. And that's your signature on here as well?
Yes, sir.
Okay. The matter will be bound over to the circuit court. Bind over date is September 6th, 2023. That's not a date you have to appear in circuit court. That's the date the circuit court's going to get this file from this court, okay?
Yes, sir.
Your next court date will be set by them after they receive the file. It'll be a pre-trial, and your attorney, Ms. Korndike, will get a copy or get notice of that next court date. So you stay in contact with her, okay?
Yes, sir.
Do you have any questions?
No.
Bond in this matter was set at 9,000 cash surety. That will continue. Any additional matters?
Nothing from the people, Your Honor.
Nothing from defense, Your Honor.
You're all set for today, sir.
Thanks.
Thank you.